The last video pointed out that the Australian Securities and Investments Commission's reluctance to act against misconduct is one thing, but to politicise the trio crime is another thing altogether. Furthermore, ASIC withheld information. The public were denied an accurate account about the trio capital fraud, the largest superannuation fraud in Australian history. Mr. John Hempton, CEO of Bronte Capital, wrote in his January 2010 blog that he tipped off the Sydney Morning Herald 6 months earlier about suspected fraud in the Absolute Alpha Fund. Absolute Alpha was the predecessor of the Astari Strategic Fund under flagship Trio Capital. Mr. Hempton's tip-off is the first publicly known warning of potential fraud. The Herald followed up the tip-off and asked the bank if it can verify Astara's assets. The bank said the assets were safe with the bank. The Herald and Mr. Hempton stopped their investigation. They didn't know at that point in time that the bank had made a mistake. The exact date is unknown when the Sydney Morning Herald approached the custodian bank. However, the lead up to September 2009 was a rapid growth period. Had the custodian paid better attention to the Herald's request, the fraud could have been stopped, saving millions of dollars of Australian retirement savings. The bank eventually discovered that it made a mistake about assets. The mistake was discovered too late. The bank apparently contacted the Herald and withdrew its initial statement. The 2012 report by the Parliamentary Joint Committee inquiry into the trio fraud doesn't comment on Mr. Hempton's experience with the Herald. In 2016, the trio victims lodged 2 Freedom of Information applications to APRA and ASIC for documents about the bank giving incorrect information. Both agencies said the document cannot be found or does not exist. Mr. Hempton was still concerned 6 months after the bank had reassured it had the money. It was the link between the Absolute Alpha and Paradigm Global that drove Hempton in September 2009 to tell his friend Ken Henry about a possible fraud. He put his concerns in writing, addressed to ASIC Chairman Tony DiLenzio. Hempton was aware that the Paradigm Fund had a checkered history. The fund, owned by Hunter Biden, his dad Joe Biden, the Vice President of the United States of America. Part of the checkered history was the 2007 Supreme Court of the State of New York lawsuit between Anthony Lotito versus Hunter and James Biden and Paradigm. Lotito accused Hunter and James of irregularities in their deal to buy Paradigm. In 2002 to 2008, another Supreme Court of New York lawsuit between Stefan Forouz and Paradigm and James and Hunter Biden. Forouz was global head of fund derivatives for the Dutch bank. He sued James and Hunter after agreeing to buy his membership interests in Paradigm, but they allegedly defrauded him. Also in 2007 to 2008, Paradigm shared its office with Ponte Negra, a firm that was found to have presented false data to achieve disgorgement of ill-gotten gains. An article published in 2021 noted that James and Hunter Biden liquidated Paradigm in 2010 and returned money to investors. This is a new detail for the trio victims. The trio victims were not notified by Paradigm, or did any of the trio victims receive an accurate account of the transactions between Astara and Paradigm. In 2012, Alan Stanford was convicted of an $8 billion Ponzi scheme, one of the largest in US history. Stanford was regarded as one of the most notorious men in the history of financial fraud. Paradigm had operated with Stanford Capital Management, a hedge fund owned by Alan Stanford and belonging at the time to members of the Vice President's family. In 2012, the Parliamentary Joint Committee report acknowledged Mr. Hempton's persistence and insight in bringing his concerns to the attention of the media and ASIC, but The only mention of the Hunter Biden fund was in a footnote. The official story about the trio capital fraud fails to mention the Bidens. The lack of transparency around the trio fraud means there are many secrets where information is hidden from the public. The 2014 laptop scandal brought public attention to Hunter Biden's businesses. He joined the board of Burisma, the holding company for a group of energy exploration and production companies, and owned by Mykola Zolochevsky. Zolochevsky is both politician and Ukrainian oligarch. Hunter Biden was paid millions of dollars by a corrupt Ukrainian oligarch for his participation on the board. When Burisma announced in 2014 that Hunter had joined its board, the White House made the following statement: Hunter Biden and other members of the Biden family are obviously private citizens, and where they work does not reflect an endorsement by the administration or by the vice president or president. In 2020, Hunter's laptop records of international business ventures and financial records became public news. Found on the laptop were large numbers of wire transfers, some with traceable addresses. They appeared to be mostly anonymous shell companies run out of lawyers' offices, moving money from Cyprus to the British Virgin Islands, with no employees and fuzzy public paper trails. There is no way to tell if the money was legal consulting fees or illegal money laundering and tax fraud. There were multi-million-dollar transfers to limited liability companies that had no employees. According to Trio staff, Sean Richard had a close relationship with Hunter Biden, and they often phoned and emailed each other. Mr. Richard visited Hunter in New York a couple of times. In September 2021, the White House issued an ethics agreement to the gallery that was exhibiting Hunter Biden's artwork. The agreement was designed to prevent influence peddling, where buyers pay exorbitant prices for Hunter's artworks, $75,000 for works on paper and $500,000 for a painting to curry favour with the president. ASIC's website states ASIC regulates banks and financial service providers, sets and enforces banking standards, and investigates and acts against misconduct in the banking sector. Parliamentary Joint Committee appeared to have accepted that the custodians had no obligation. The committee wrote, "The custodian does not have the expertise to question underlying values of either domestic or offshore funds." In October 2018, the Banking Royal Commission released its interim report, and Executive Officer Mr. Shane Elliott invited disgruntled bank customers to email him directly with their concerns. In October 2018, the Trio victims asked whether the custodian for Trio was exempt from AML/CTF law when $194.5 million went overseas. Mr. Shane Elliott wrote, "I refer to the letter by email dated 16th of October 2018. ANZ is not exempt from AML/CTF law and is required to and does meet its reporting obligations to AUSTRAC, including the obligation to report all cross-border fund transfers. Mr. Elliott took the bank's anti-money laundering obligation seriously. The committee's 2012 report seems to deflect responsibility by the custodians when it writes, "The custodian does virtually nothing to protect the funds of investors. It makes no independent checks before transferring money offshore. Instead, the custodian simply acts on the instructions of the responsible entity." In 2004, did Mr. Richard breach the Corporations Act over a conflict of interest? In 2006, APRA found the Trio directors were a bunch of incompetents. APRA met with the Trio directors and carried out 4 or 5 prudential reviews during the 5 years the fund operated. So, APRA was better placed to have known what exactly meant by the bunch of incompetents. So why didn't APRA take action, and why didn't APRA inform creditors? When asked why APRA didn't inform creditors, APRA's Ross Jones said APRA had no obligations to inform the market. In 2005, one of the directors of the Astara Fund handed a complaint letter to the Trio board. One of the complaints included conflicts of interest. Potentially, the 2005 complaint letter was a red flag. When the letter was delivered to the Trio board, APRA was conducting a prudential review of Trio. The person who wrote the letter was satisfied APRA would deal with the problem. Only 8 years later, the letter writer discovered that the letter made no difference. A single in-specie transfer of more than 50 million was sent to a foreign tax haven, but there is no evidence that a suspicious transaction report was lodged, as is required by law. During the so-called Trio investigation, 2010 to 2012, ASIC, APRA and AUSTRAC did not ask questions about the 50 million transfer. The Parliamentary Joint Committee stated the committee did not receive a submission or take direct evidence from the Australian Reports and Analysis Centre, AUSTRAC. It does appear, however, that AUSTRAC was not given any significant information from the various gatekeepers alerting it to suspicious activities in the Trio capital fraud. A New South Wales Supreme Court judge convicted Sean Richard of dishonest conduct while running a financial service business. Mr. Richard lied to everybody. He lied to ASIC about his qualifications. He lied to consumers. ASIC issued Richard with an Australian financial service licence without checking his qualifications or background. The lie on the ASIC Australian financial service licence got him into the financial sector where the retirement savings of decent Australians were stolen. It was as if ASIC rolled out the welcome mat. There is no indication that ASIC served the interests of the people when it governed the running of the Trio scheme, or its so-called investigation of the Trio crime. The information withheld from the public by ASIC undermined the understanding of the Trio fraud and wrongly made consumers appear to be outside of the law. Consumers' retirement savings were legally placed into the financial system, but as the unresolved issues in this video demonstrated, their rights were demolished by the politicisation of the Trio crime by a directive to ASIC from a politician.